Welcome to this session of oral argument of the 5th District Court of Appeals. As previously indicated, I'm Judge Sawaya. To my right is Judge Evander, and to my left is Judge Lambert. And it's our pleasure to preside over the cases on the docket this morning. We have 4 cases on the docket. If anyone is here on Bradford Development versus Caneenan, that oral argument has been dispensed with. So we'll proceed with the cases as listed in the order on the docket. The criminal cases will be allotted 15 minutes per side, civil cases 20 minutes per side. If the appellant wishes to reserve any time for rebuttal, please let me know. We have a clock on the podium that will assist you with that. If you have any problems with that, let me know and I'll try and assist you in keeping time. If anybody has any electronic devices that may go off during the course of the oral argument, we request that you turn those off so that we're not interrupted. So with that, we'll begin with the first case, Mosby versus State.
Good morning. May it please the court. My name is Jerry Delgado, and I'm here on behalf of the appellant, TYRONE Mosby. I'd like to request 5 minutes for rebuttal.
Okay.
5 issues were raised in initial brief. The last issue, dealing with the sentencing error, has been conceded by the state, so I don't believe any other discussion on that will be necessary today.
Why wasn't that addressed at the by the trial court? It seems to me like what the trial court did was just let the 60 days run and it was an automatic denial. Is that right?
Yes, that's correct.
Why didn't the trial court address that, the state's concession? It seemed like they may have filed it late, maybe just a few days before the 60 days ran, but still I would have thought that the trial court would have addressed it.
Sure, I don't really know why the trial court did not address it.
Okay, so anyway, so that issue is taken care of. Is that correct? I mean, you would agree with that? Reverse it and send it back for resentencing on that? Okay, so go ahead and proceed with the other issue.
Sure. I'd like to focus today on 2 issues. The first being the Brady issue, and the second being the competency issue. And before I begin my Brady argument, I'd like to point out to the court that in my initial brief, I misstated a fact concerning the proffered statement. In that statement, the proffer did not identify anyone else as the shooter. That only affects arguments made as to that piece of Brady material, but it does not change its characterization as Brady material. In Brady v. Maryland, the United States Supreme Court established the now familiar principle that all favorable material must be turned over to the defense before trial. This case presents a flagrant violation of that principle. The state in this case convicted Mr. Mosby based on one key witness, and that was Mr. Robert Joseph. Mr. Robert Joseph was the only piece of evidence tying Mr. Mosby to this case. However, unknown to the defense, there were 2 critical pieces of Brady material that were withheld. One was the recorded interview of Mr. Robert Joseph, where he identified someone else as the shooter, and second, the recorded interview of Amon Mitchell, where he identified someone else as the shooter. The suppression of these statements alone undercut the entire state's case. They serve both to be exculpatory and impeachment. This evidence alone cast doubt on his whole role and involvement in the shootings. If all that information had been disclosed before trial, the defense would have been able to present that to the jury, and it would have you would have viewed this case in a completely different light as to undermine our confidence in the verdict. Therefore, the trial court erred by rejecting Mosby's Brady claim, and its judgment should be reversed. And it's important to remember when you view Brady material that not every piece of the state's case needs to be directly undercut. I'm not saying that the state didn't have enough to go to the jury. However, the remaining evidence left unscathed hardly amounts to overwhelming proof against Mr. Mosby. I'd also like to address a point made by the state regarding Amon Mitchell's recorded statement. The state takes the position that that was just preliminary investigative material, not subject to the discovery rules.
Hey, as to the Brady material, you have the burden of establishing that it may have produced a different result. The state says you didn't do that. Explain how you did.
I believe I did that. Well, first, the burden is that it's a reasonable probability of a different verdict, in that, I'm sorry?
Go ahead and explain that then.
Sure. The only thing tying Mr. Mosby to this murder was Mr. Robert Joseph's identification of him as the driver and shooter. However, in his recorded interview that wasn't disclosed, he identified somebody with dreads as the shooter. Mr. Mosby does not have dreads. So not only is that in part exculpatory, it is contradictory to his trial testimony.
Okay, that statement was not recorded. It was just spoken to somebody else. He testified that that's what he said. Is that what you're saying? Or?
That was recorded. That was a recorded interview with the police.
Pardon?
That was recorded in a recorded interview with the police.
Okay, it was in a recorded interview. Your claim is that he identified somebody else.
Correct.
Go ahead.
And the second piece of information was the recording of Amon Mitchell, where he described Sutton as the shooter. And he wasn't present, but he did say that he heard from the streets that it was Sutton who was the shooter.
But the state's case wasn't that your client was the actual shooter, was it? Wasn't it? I mean, in the first incident it was, but as far as the girl, the passerby who was hit, they weren't claiming that your client was the actual shooter. It wasn't the state's theory of the case was that your client was the driver.
That's correct. He was charged as principal.
So if someone else was the shooter, then how does that affect the result in the case?
It serves as impeachment to Mr. Robert Joseph's trial testimony because he was present during that phone call and he heard Amon Mitchell describe someone else as a shooter. So the defense was first not able to investigate Amon Mitchell's statement, and he wasn't able to cross-examine Mr. Robert Joseph on that statement.
But the state's theory was that the first incident in the driveway, that your client was the shooter. And then the second incident, the shooting during the chase, the car chase, if you would, was that another individual was the shooter. Now, Mr. Mitchell's statement only indicated that the shooter in the second incident was someone other than your client, correct?
That's correct.
So that would not be inconsistent with the state's theory on the second shooting.
That's correct, but all the state really had to go on was the word of Mr. Joseph. He was the main feature of their case, and his credibility and his identification of Mr. Mosby was key to their case.
But how does Mr. Mitchell's statement impeach that statement? Because he never said that Mosby was the shooter, during the car chase, did he?
Sure, well, it just goes to, I maintain that it still does, the defense counsel wasn't able to investigate this or ask about this to Mr. Joseph.
What did the trial court say about that? What was the trial court's ruling was what?
She denied the Brady claim.
Isn't that basically what the trial court thought as well, don't you think?
It's hard to know because she didn't really, I'm sorry?
Affect the outcome. There was no reasonable probability there's going to be this was going to affect the outcome of the case, right?
I think this information was very important.
I'm thinking that's what the trial court thought as well.
I believe so, since she denied the claim. She didn't make certain findings. The only thing she really made findings on was the video.
Okay.
But she didn't make particular findings on these pieces of evidence.
What is your strongest claim in this case? What is your strongest claim for reversal?
I believe it's Mr. Robert Joseph's recording and Mr. Amon Mitchell's recording, those two. And also, I just want to point out that when you're looking at Brady claims, you don't look at each piece individually. I mean, they need to be viewed collectively to determine their prejudice. So, if the court has no further questions on the Brady claim, I can move to the competency.
Yeah, you can move on.
Okay. A defendant has a due process right to be competent when sentenced. In this case, the experts were all in agreement that Mr. Mosby was competent for sentencing and incompetent for trial.
Can't that happen?
I'm sorry?
Didn't the experts explain that being competent for trial, there's more involved in the processing of the trial as opposed to now you're being sentenced, you have to understand what you're exposed to and be able to talk to your lawyer about sentencing issues?
Sure, that was the standard they applied, but I don't think that they have any law or support for that. That's something that they sort of made up.
So
I mean,
it's a black or white, either you're competent for everything or you're incompetent for everything in the process, in the concept of a criminal proceeding?
well, the way I read the rules is that when competency is raised, there's a certain factors that you apply, and the only distinction that I see, depending on the proceeding from the rules, is whether it's a material proceeding or not. And sentencing is a material proceeding, and therefore those factors should be applied.
Well, what's the test for competency, whether it's for trial or sentencing? Is it the ability to be able to assist your attorney?
Yes, that's part of it. It's the Dusky standard, whether defendant has sufficient present ability to consult with his lawyer with a reasonable degree of rational understanding, and whether he has a rational as well as factual understanding of the proceedings against him.
All right, well, leaving out the sentencing issue, could a defendant be competent to assist their attorney, if you would, or able to assist their attorney even with limited cognitive abilities in maybe a battery case where the only issue is who hit who first versus a complex racketeering case? I mean, in other words, could the same individual be competent in one case and then a day later be appropriately be determined to be incompetent on a complex case?
Well, I think what that goes to is, in this case, and in that case, I think this applies too, the experts did not think that, at least one of the experts thought that Mosby could not testify in an acceptable manner. And the ability to testify is fundamental to your right as a defendant. I mean, you need that.
Going back to my hypothetical, could you have a defendant, say they had trial set, battery case on Monday, and then a long racketeering case scheduled the next day, and you had one simple issue in the battery case and a very complex case in the other? Could an expert properly, applying the correct standard, determine that the defendant was competent for the battery case because they were able to assist their attorney, but because of their limited cognitive abilities was not competent for the second case?
I think if you apply the factors to different cases, it might come into play.
Well, isn't that what the experts here did? But it was the same case, but one was with regard to trial, and one was with regard to sentence.
I think the experts in this case just kind of thought that all you need to know for sentencing is that you're about to receive punishment. I mean, I don't think that they applied the factors. They just kind of took their own understanding of what you need for sentencing. But sentencing is material. It does require testifying, and the defendant might need to consult with his attorney about certain mitigation factors.
These are all experts who are familiar with the standard of determining competency in criminal proceedings, because the three of them, they've all testified apparently many times prior to that. So it doesn't seem like this is a concept that would be lost on them, and they examined it, and they, as Judge Evander's indicating, there can be degrees of competency. I mean, kind of akin to a guardianship proceeding. When you have an incapacity, you have certain rights you may be incapacitated for. You can't execute a will, you can't drive, but you have the ability to marry. For as a circuit judge, you make those determinations. It's not an all or nothing incapacity. Why is that not? I mean, I know it's a different.
Sure, I think.
Why is that not analogous?
Well, I think part of the issue in this case is that competency normally isn't raised post-verdict. You usually don't have the situation. There's not a ton of case law on that because it's usually known, and in this case, these aren't new ailments that Mr. Mosby suffers from. These are probably things that existed before trial.
You never said as a circuit judge then. A lot of times when they get ready to get sentenced, all of a sudden they view of the world. They're incompetent.
Yeah, okay, you've got about a minute and 50 seconds.
Sure, I'd like to reserve the remaining of my time for rebuttal.
Well, her claim is that her strongest claim is Brady, so you want to just go ahead and address that first.
Sure.
You can introduce yourself if you want.
Okay, please, the court. Good morning, Kelly Dealer on behalf of the state of Florida. There were two shootings in this case. It was never disputed that Mr. Mosby was not the shooter of Ms. Sampson. He was only accused of being the actual shooter of Chester Joseph. All the statement, Mr. Joseph's statement and the statement of Amon Mitchell during that when he's on the telephone, talk about the second shooting. And even in Amon Mitchell's statement, he says that there were 3 people in the car. Sutton was the shooter in the front passenger seat, Tyrone was the driver, and Roberts was in the back passenger seat. Mosby's first name is Tyrone. I mean, all of the evidence implicates Mosby as the driver of this car and as the shooter at Mr. Joseph in the first incident, and Mosby as the driver as they were leaving that scene, and either a front seat passenger, although most of the evidence indicated it was the back seat passenger that was leaning out the window that was firing those shots. None of these statements are conflict with any of the evidence, and none of them are exculpatory. So it's our position that the trial court correctly found that this would not have affected the verdict at all. And I just wanted to clarify, make sure that the court understood that these statements did pertain to the second shooting and not the first shooting. And if there are no further questions, then thank you.
Got about a minute and 50 seconds.
The Brady standard has been around for nearly half a century. There really is no ambiguity about what the standard requires. I think in this case, this material...
It's your burden to establish it. There would have been a different result. I'm having a hard time understanding how that's been established in this case. Under the facts and circumstances, and you know, the facts and circumstances of each incident and what was alleged by the state and what was charged by the state. I mean, maybe you can clarify a little bit more if you want to, but that's the problem I'm having with your Brady claim.
Sure, and well, as to the material we already talked about, I mean, my position is that it's also impeachment of Mr. Joseph, which we already talked about. And as to the second set of things, which would be the proffered statement in the video, below, because of the protective order, the defense attorney was not permitted to call those witnesses at the hearing, wasn't allowed to investigate it, or tell the client about Mr. Mosby about these things. So she wasn't able to really get to the bottom of the prejudice. So at least to that second set, we don't know the full nature of the prejudice. And I know it's our burden, but she was stifled from doing her job. So, and if that's all, I believe the trial court erred by rejecting Mosby's Brady's claim, and for that reason, the judgment should be reversed.
Thank you.
Thank you.
Both very much.